And with that, I would like to welcome you all to a very special event in the annual life of the program in Law and Public Affairs, which is a program around here that we call LAPA. The special event is the Donald S. Bernstein Class of 1975 lecture. I'm Kim Shepley. I'm the director of the program in Law and Public Affairs, and I first want to say what an inspiration the Bernstein lecture and also Don Bernstein himself are to us at LAPA. Don Bernstein's vision for the study of law at Princeton asks us to consider big questions and core values. And it asks us also to consider what law can contribute to public debates over the major issues of our times. Law for Don Bernstein is not just a set of answers to technical questions. Law is the framework through which we collectively maintain our principles and solve our common problems. LAPA has been inspired by his vision and very grateful for his continuing support of the study of law at Princeton. It is particularly fitting that our Bernstein lecturer for this year is the Honorable Dorit Beinisch, President of the Supreme Court of Israel. Justice Beinisch has been a justice on the Israeli Supreme Court since 1995 and President of the Court since 2006. And I am happy to say that finally the Israeli Supreme Court has its first woman president ever to hold that post. This year at LAPA, we have been delighted to honor the tremendous contributions of women in high judiciaries around the world. In the fall, our Harlan lecture brought Justice Ruth Bader Ginsburg of the United States Supreme Court to campus, and we are pleased to continue in this tradition by having Justice Beinisch with us tonight. While she is the first woman president of her court, I must say she does not serve alone. Several other women join her on the bench, something Justice Ginsburg delighted in telling us and hoping for that in the U.S. as well when she visited in the fall. Born in Tel Aviv, Justice Beinisch completed her Army service with the rank of First Lieutenant, after which she began...
This was long ago.
It's important, actually, in what you're about to talk about tonight. And after that, she began her law studies at Hebrew University, where she earned both a bachelor's and master's of law. From there, she began her career in public service in the Israeli Ministry of Justice, where she served as senior attorney in the criminal law department and director of the Department of Constitutional and Administrative Law. In 1982, she became the deputy state attorney and 6 years later, state attorney of Israel, before being appointed as justice of the Supreme Court. Now, before you hear her speak tonight, it's important to know a little bit of something about the Supreme Court of Israel, because the Supreme Court of Israel is an institution whose range of responsibilities is far wider than those of the Supreme Court of the United States. And as we just learned in talking to her before the session, it's also the case that their caseload is a lot bigger than the United States Supreme Court. So whereas the United States Supreme Court now issues 60, 70, maybe in a good year, 80 opinions, the Supreme Court of Israel typically has 5,000 cases a year. Now, why is that? This is because the Israeli Supreme Court is the highest court of appeal for civil and criminal matters as a matter of right, as the lawyers would say. And for everyone in the room, what that means is that they can't refuse to hear an appeal that comes to them from the ordinary civil and criminal courts. So much of its docket is jammed with ordinary appeals and ordinary cases that they have to hear. But there's also more to the Supreme Court than simply being the most important court for ordinary legal matters. The Israeli Supreme Court can also sit as the High Court of Justice. And when it is acting as the High Court of Justice, the Supreme Court can exercise judicial review over other branches of government, and it has the power, I love this quotation, quote, in matters in which it considers it necessary to grant relief in the interests of justice, and which are not within the jurisdiction of any other court or tribunal, unquote. Which is to say, this is a court that can do almost anything. And in fact, it has. This grant of power is exceptionally broad, and in the history of the court, it has used this power to put its stamp on almost every aspect of Israeli public life. And so what I want to say about the Israeli Supreme Court is that there is hardly any issue in public life that this court has left untouched. It has 60 years of jurisprudence. There is no topic about which it does not have an opinion. Those of us who work in the field of comparative law know that if there is a legal question that has some opinion somewhere, it's likely to have come from the Supreme Court of Israel. And so with all of that, it's probably also worth saying that as the Israeli Supreme Court exercises this authority, one of the things it has to do is to decide on the constitutionality of state action and state laws. And here's where there's another challenge for the Israeli Supreme Court, which is, unlike many countries that have a constitution embodied in a single complete text, in Israel, there are pieces of a constitution, 9 basic laws, as it were, and no single coherent text. And so what I want to say to you tonight is we are about to hear from a remarkable woman who is the president of a court that hears 5,000 cases a year with a constitution that's not complete and that has to deal with every single issue that one can imagine under the legal sun, and that has to do it in a context in which there is no issue in Israel that commands uniform agreement. And so controversy is something it is built for, something that it gets. Among the many reasons why we're thrilled to have Dorit Beinisch with us tonight is that one of the key issues in which the Israeli Supreme Court has issued more judgments than any other court, and something that now every other country has to wrestle with, is the topic of terrorism. And so the Supreme Court of Israel has a very dense and deep and thick jurisprudence that I know is very important and very helpful for courts around the world as they begin to think about these issues. And so we're thrilled that Dorit Beinisch is with us tonight to talk about defending human rights in times of terror. And with us, Dorit Beinisch.
Thank you, Kim, for this wonderful introduction. As to the court, I almost started to believe. So I really thank you so much, and I'm glad that I have the opportunity to introduce with some of our approach and the decisions to very complicated issues regarding protecting human rights in times of terror, and maybe discuss with you those issues. I want first of all to thank Kim, your wonderful program, and Dorit for giving me this opportunity tonight, and I want to thank all of those distinguished guests that came tonight and waited so patiently. It's not our fault, but it happens, and thank you for coming. I hope when I hear that there are people in the other room that I won't disappoint. This performance is nothing very sensational, but we'll try. Well, as we all know, terrorism is not a new phenomenon. Yet over the last decade, terrorism evolved to new dimensions and has become a serious threat to democratic states. Indeed, we all face the reality of vicious and cruel, I hope it's okay to me, of vicious and cruel terror that knows no bounds. And as the plague of terror is spreading throughout the world, we all share the same concerns. Terrorism presents new and different challenges to human rights. On the one hand, danger to innocent people lies everywhere. At all times, men, women, and children are always at risk in public places, in streets, and even in the privacy of their own homes. On the other hand, and this is of course a reality that we in Israel know, unfortunately, very closely. Reaction to terrorism may also harm human rights. Unfortunately, we are all familiar with the phenomenon of suicide bombers who cannot be deterred by traditional means of law enforcement. Therefore, governments and legislatures in democratic states introduced extreme measures aimed to cope with terrorism, such as profiling, racial profiling, administrative arrests and detentions, deportations, limitations on freedom of movement, and various other limitations on people's rights. It is a difficult and complicated struggle. The courts took upon themselves the difficult role of scrutinizing the decisions and legislation that were introduced during the fight against terrorism, with the goal of preserving human rights while maintaining security. In Israel, since its early days, the Supreme Court took on the difficult and complex task of maintaining the conditions necessary to protect the society in a permanent state of emergency, while preserving the rule of law and basic human rights. In one of our decisions, we stated, and this is really reflecting what we know and feel. Since the founding of the state, the organs of the government have been faced with the need to protect the security of the state and its citizens, a need which sometimes requires placing limitations on certain rights in order to provide security and the protection of life. For years, our case law has contended with the conflict between these two poles and dealt with it successfully. This tension has increased in recent years for reasons arising from the difficult security position on one hand and from reasons based on the enshrining of basic human rights as constitutional super-legislative rights on the other. But the strength of the tension cannot exempt us from the need to exercise our judicial review and examine the constitutionality of the law even when the factual position is complex. End of quote. Indeed, since September 2000, a wave of terror attacks and gun battles forced Israel into a period of armed conflict. The government took steps to fight terrorism, and the court was flooded with petitions requiring us to adjudicate the proper balance between the need to protect the public and preserve security, and at the same time the need to preserve basic human rights. We live in a period of constant tension between ensuring security and safeguarding human rights. The public demands security, and the government is under pressure to protect the public and ensure peaceful and safe life. That's the role of the government. The court is part of Israeli society. As justices, we share its concerns, yet we recognize our role and our responsibilities. We acknowledge the duty of the executive to protect the citizens and preserve their right to life against the threat of terrorism. We also recognize, however, that it is the duty of the judiciary to guarantee that a nation fighting for its survival will not sacrifice those very values that make the fight worthwhile. The level of protection, of course, of human rights in times of peace differs from their protection in times of war and armed conflict, when naturally the balance between security and human rights shifts. But if the state does not protect human rights in times of emergency, it may lose its democratic character in times of peace. It is the difficult role of the judiciary to guard against disproportionate limitation on basic human rights of every individual, including terrorists, even in times of emergency. In today's reality, our court confronts the challenge of balancing these dual values of security and human rights on a daily basis. I believe that no other court in the world faces so many cases involving issues of safeguarding human rights and humanitarian consideration while fighting terrorism in such a complicated reality. Our guiding principle is that the battle against terrorism must be fought within the law, and that no war may take place outside the boundaries prescribed by law. And how do we do it? 5 aspects of our judicial review make the Supreme Court particularly responsive to the needs of our time. Broad access to the court, facilitated by the practical elimination of any requirement of the right of standing. The fact that the court almost never closes its doors on grounds of injusticiability and is willing to apply judicial review to government activities, including military and military operations. 3, when necessary under the circumstances, judicial review is exercised in real time rather than retrospectively, because ex facto review in these cases is not effective sometimes. The use of international law as a substantive law and as an interpretive guide, and I'll elaborate on each of these characteristics, and the status of the court as the highest court of the land. And I'll just mention more detail on those 5 characteristics. When basic human rights are at stake, the doors of the Supreme Court are open to anyone seeking a remedy against any activity of the executive branch or against any public authority, including military. Everybody, Israelis, Palestinian residents of the territories or aliens, all have direct access to the Supreme Court, which is unusual because in this, and I'll explain later why, we are first and last instance and we are not an appellate court. So all have access to the court irrespective of citizenship. Palestinian residents of the territories who are not subject to Israeli law have the same rights to approach the court as do Israeli citizens. There is no requirement of the right of standing, which allows civil rights groups and NGOs to challenge measures taken against Palestinians in the territories, which is often how such cases reach the court. Over the years, Palestinian residents of the territories have submitted thousands of petitions against the military commander of the territories. Although Israeli law does not apply to the territories, our judicial review is based on the duty of government officials and military officials to act according to Israeli law and to comply with norms of international law, even when they exercise their authority beyond states' borders. Now, the other factor is the justiciability of every issue. When the court scrutinizes military operations or any other state measure implemented in the course of the fight against terrorism, time and again, the state argues that these actions or decisions are not justiciable, since they are political in nature and due to the fact that the court has no special expertise in such matters. In various cases concerning measures such as security interrogation, a case that was just lately cited in the American Supreme Court judgment, measures of security interrogation of suspected terrorists, targeted killings, and security fence, the court rejected all these injusticiability arguments. In all of these cases, the court emphasized that when a claim of direct violation of human rights is raised, the suit is always justiciable. Thus, the court affirmed that there are no black holes with no judicial review. We do, of course, recognize that the political nature of some issues renders them outside the appropriate purview of the court. But these cases are the exception, not the rule. It sometimes happens, and it happens, that petitioners come against agreement to release prisoners, which part of agreement with Palestinian Authority. We will not interfere in this kind of cases because they are really political in nature. But due to this stance, the court has often attracted criticism from jurists, from politicians, and sometimes from the public. As to the scope of judicial review, when the court scrutinizes security decisions that were made on the basis of experience and expertise of the military professionals, the court will examine whether the security measures taken fall within the zone of reasonableness and are proportional, such that a military commander was permitted to make. In the regard, our basic thought and premise is that the court should not adopt a position on the question on what the most appropriate security measures for the war against terrorism are. We do not choose the measures. We do not decide instead of a military commander. But we do review the appropriateness of the security measures, as I said, if they were taken for a good purpose, for necessity, and that it is reasonable and proportionate to this need. So long as the other branches are using measures that are within their authority and meet the requirement of proportionality, there is no justification for judicial intervention. It is also important to know that security considerations are not magic words that the court accepts whenever raised. It is natural for a commander-in-chief, for the military, for the government to feel that they give more security. It's natural that they want the maximum. I can understand it, but this is not enough. This is one of the concerns, this is not enough. So when they use security consideration, those, as I said, are not magic words. Therefore, the court must examine carefully the relevant information laid before it and the reasoning behind the specific security measure. When the court is convinced that the security consideration is real and is the dominant consideration, and that the security measure is proportionate and in accordance with the necessary security purpose, the petition against the action is dismissed. It should be mentioned in this regard that sometimes security information is confidential and is given to the court ex parte without the presence of a petitioner or their lawyers. This is very problematic, especially in cases of administrative detentions or limitations on the freedom of movement of individual suspects. This obligates the court to examine the security information very carefully, with an open mind, a critical approach, and as objectively as possible. In this regard, our court usually enjoys much credibility from both sides, which trust us to evaluate correctly the material laid before us. Yet this method is not always satisfactory. I can tell you that other courts in the world have examined the same issue of how to handle confidential evidence. It was in Canada, it was in Great Britain, I think it was even in the States. Some found different solutions, as having a special attorney to be appointed. Still, an appropriate solution for this problem is yet to be found. And, as I mentioned before, one of the characteristics is to review the case in real time. Nearly every day, justices of the Supreme Court consider all sorts of requests for injunctions against the use of different measures taken in the name of security. When necessary, under the circumstances, the court may grant injunctions immediately, even before it decides the legality of the acts themselves. This is a vital tool, as reviewing the legality of the acts in retrospect after they have been carried out would often be ineffective. And I'll mention it later. We did it even during the last military operation in Gaza. Thus, for example, the court issued injunctions in many cases regarding the erection of the security fence before the legality of the fence was in fact determined. Despite being the Supreme Court of the country, in certain cases, as I mentioned already before, we are original jurisdiction, first and last instance. In the cases that are dealt with in real time, we are often called to determine the facts after affidavits are submitted to the court. Accordingly, we need information regarding developments of the situation at the issue. And in some very exceptional cases, we needed updating during the hearings about the changing situation in the field. When people come to the court, approach the court for having humanitarian assistance, medical assistance, water supply, even during a military operation, we have to be updated if they're really supplied, because the state always declares that they are ready to supply it. They never say that they are not obliged to, and they are right. So then we have to get the information if things are really done like that. In one of our cases, the court emphasized the difficulty of applying judicial review and exercising a fact-finding process before the combat comes to an end. Nevertheless, the court reasoned that it is important to assure the implementation of humanitarian principles during combat, such as supply of water and medical care, as I mentioned before. An important tool in protecting human rights while in a state of emergency is the court's use of international law. In the territories, which is a very special situation for Israel, they are kept under military control, but the basic legal norm relies on international law, namely the law of belligerent occupation, the Hague Regulation of 1907, and the humanitarian principles of the Fourth Geneva Convention are legally binding, and according to them, the territories are subject to special military rules and orders. Israeli citizens, Jews and Arabs alike, are subject to domestic Israeli law. Therefore, when dealing with Israeli citizens who are involved in terrorist activity, we generally apply domestic criminal law using international law mainly as a source of interpretive guidance, but of course, it's not authoritative. The legal difficulties with which we must contend when implementing international law stem primarily from the fact that international law has not yet developed the laws of armed conflict to respond to the fight against terrorist organizations, as opposed to regular army. Therefore, we use interpretational tools in order to adapt the existing humanitarian laws to the difficult reality with which the entire international community is confronted. In our judgment concerning the Israeli policy of targeted killing, which causes the death of terrorists who plan, launch, or commit terrorist attacks in Israel and in the territories, we determined that under international law, members of terrorist organizations have the status of civilians and therefore applied and interpreted Article 51.3 of the First Additional Protocol to the Geneva Convention. According to this article, and I quote, civilians shall enjoy the protection afforded by this section unless and for such time as they take a direct part in hostilities. Being the first court ever to apply this article on such circumstances, we had to interpret it and determine its scope, the applicability to our unique situation. We decided that the legality of each act must be scrutinized and determined individually, and emphasized that the legality of each individual such act should be determined in light of 4 basic principles that limit the power of the military to employ this means. First, well-based, strong and convincing information is needed before categorizing a civilian as falling into one of the discussed categories. Second, a civilian taking a direct part in hostilities cannot be attacked if less harmful means can be employed, which is unfortunately impossible now talking about Gaza. A civilian taking, most of the cases, not in all of them, a civilian taking a direct part in hostilities does not relinquish his human rights. He must not be harmed more than necessary for the needs of security. Third, after an attack on a civilian suspected of, at the time, taking an active part in hostilities, a thorough and independent investigation regarding the precision of the identification of the target and the circumstances of attack upon him is to be performed. This is, of course, retroactively. In appropriate cases, compensation should be paid as a result of harm caused to an innocent civilian. Fourth, every effort must be made to avoid or minimize harm to innocent civilians. Any harm of innocent civilians caused during military attacks, known as collateral damage, must be proportional. Finally, we noted that in a democracy, the fight against terror is subject to the rule of law. In its fight against international terrorism, Israel must act according to the rules of international law. Later on, as much as I know, this is how this protocol was interpreted, not only by us, but by international law. These rules are based on a delicate balancing between security needs and human rights. The need to balance casts a heavy load upon those whose job is to provide security. Not every effective means is also legal. The ends do not always justify the means. Another characteristic of our judicial approach is our growing tendency to apply principles that are based on human rights conventions, such as International Covenant on Civil and Political Rights, and they are not binding Israel. We are we signed those agreements, those conventions, but we didn't legislate. And as long as it is not legislated by our Knesset, by our parliament, it is not binding, but this is guiding for us because Israel is part of this community. So we decided that not only the law of belligerent occupation, but also International Covenant of Civil and Political Rights should be interpreted and, if possible, also applied. Indeed, in ruling on hundreds of cases regarding the procedures and conditions of prisoner detention and of the measures imposed on suspected terrorists, we intervened to set out detailed standards of shelter, hygiene, medical treatment, the right to meet a lawyer, length of detention restrictions, and access to judicial review, and many other requirements of the Fourth Geneva Convention. Of course, the status of the court as the Supreme Court, the highest court in the country, and the public trust and deference which accompanies such status gives the court its power to render unpopular decisions. It's important to mention that the very existence of the Supreme Court's jurisdiction and the jurisdiction to apply judicial review the willingness to review almost any government and military act in itself serves as an important check on the executive decision-making. As I was part of the executive years ago, I can tell you that many decisions are first checked by the lawyers if it is possible to defend in the Supreme Court. And this in itself serves as a restraint. I want to give you some of our some of our examples of those cases that I mentioned before. A very important issue is the issue of administrative detentions. Unfortunately, as you know, this is a necessity which we really do not like. But this is a necessity, as I mentioned before, sometimes because not all those suspected people could be brought to trial, not all the evidence could be revealed. So the legality of administrative detentions and the legal constraints occupy different courts around the world. In Israel, it is not a new concern. The Supreme Court has dealt over the years with many petitions regarding the power of the state to arrest suspected terrorists and the conditions of their confinement, and they come also on an individual basis to the court. And, of course, general considerations. One of the important examples was it was in 2003, in the case where the court reviewed the legality of administrative detentions of large number of suspected terrorists for the purpose of interrogation. The court ruled that detaining a large number of people is allowed, provided there are reasonable grounds of suspicions that each individual detainee poses a security threat. The court stressed that the circumstances surrounding the person's detention must be such that they raise the suspicion that the individual present he himself presents a danger to security. In the specific circumstances of the case, the court held that the army had met this standard. But at that time, we also decided that it didn't meet all the standards needed because they didn't have to bring the detainees to a neutral judicial authority to review. So the court found that the detainees has been deprived of the right to prompt evaluation of their detention by a neutral judicial officer. In this regard, the court held that the order issued by the commander of the military forces, which authorized the detention of persons for 18 days, or then amended to 12 days, without bringing him or her before a judicial authority, contravenes fundamental principles of international and Israeli law. President Barak stated in his opinion that the Fourth Geneva Convention does not include provisions which specifies set detention periods or occasions for judicial review with regard to detention. Nevertheless, he concluded that the general principle which pervades international law is that the question of detention is to be brought promptly before a judge or other official with judiciary authority. In the territories, it's a military, which is not very satisfactory, but this is the judicial institution that we have. Following this decision, the army, but after a decision of the military judge, he may come to our Supreme Court and challenge the decision. Following this decision, the army regulations were changed, and the period between the detention and first instance of judicial review of the detention was considerably shortened. As I said before, administrative detention still raises many problems, such as the issue of handling confidential evidence, and as long periods as well with long periods of confinement. Nonetheless, they form a necessary evil in the complicated and complex fight against terrorism, as opposed to fighting regular army. And one of the decisions that was taken, and I'll talk about it. Next example, the Knesset legislated a law that allowed the internment of what was called or defined by law as unlawful combatants. In June this year, the last year, we gave our judgment regarding the new legislation of the law named the internment of unlawful combatants. a law that enabled the detention of unlawful combatants as defined by the law for an unlimited period, instead of war prisoners. They said, the law stated that they are unlawful combatants and they could be kept in detention as long as the activities of war, as the armed conflict is going on. We had appeals that challenged specific internment orders that were made under this law, but the case focused mainly on fundamental questions concerning the interpretations of the provisions of the internment of unlawful combatants and the extent to which it is consistent with international humanitarian norms. I must say that the law itself stated that it is legislated in accordance with the norms of international humanitarian norms, and that gave us, of course, the power to review this law with accordance to international norms and, of course, our constitutional concerns. In our judgment, we held that the administrative detention that was introduced by this law regarding detainees who are not in the status of war prisoners is a measure that severely violates the right to personal liberty. Therefore, we decided that interpretive efforts should be made in order to minimize, insofar as possible, the violation of the right to liberty. We also held that the provisions of the statute should be interpreted insofar as possible in a manner consistent with the accepted norms of international law, which means through the narrow interpretation of the relevant provisions of the law, we minimize the harm to basic rights of the detainees without really causing harm to security needs. Thus, we believe that we achieve the right balance between the conflicting considerations without declaring the law unconstitutional. Among the main principles that we stated is that the interpretation of the definition of unlawful combatant is subject to constitutional principles and international humanitarian law that require proof of an individual threat as a basis for administrative detention. Accordingly, we held that for the purpose of detention under the law, the state is required to prove with administrative evidence that the detainee directly or indirectly played a real part, which is not negligible or marginal, in the hostilities against the state of Israel. We didn't accept the original definition of the law, which included the mere belonging to a terror organization without the need to prove any contribution to the organization's activities. This is what the law stated is a presumption, but we didn't accept it as a presumption because we decided that it should be proved that he had a contribution to the organization's activity as a justification for detention. In our judgment, we said that proving the condition of the definition of unlawful combatant is the aforesaid sense includes providing and proving a personal threat that derives from the actual type of the detainee's involvement in the terrorist organization. We also held that because administrative detention is an exceptional and extreme measure, and in view of the significant violation of constitutional right to personal liberty, the state should prove with clear and convincing evidence that the conditions of the definition of unlawful combatant are satisfied and that the continuation of the detention is essential both in the initial judicial review and the periodic judicial review, because there is a periodic judicial review according to the law. In this regard, we held that importance should be attached to the quantity and quality of the evidence against the detainee, and also to whether the relevant intelligence information against him is up to date. This is not easy for the state, because they bring these detainees from an area that our military and security people do not have direct access. This year, it is kept by the Hamas organization. Sometimes those are the cases, yet they have to prove at least some quantity of real evidence, administrative evidence, not evidence that is accepted in court. Finally, it is important to mention that our decision includes other limitations on applying this law. There has to be periodic judicial review on the time of the detention, and the court that exercises the judicial review of the detention may shorten the period of detention in view of the nature and strength of the evidence brought before it. Moreover, we said that the state has to make an effort to shorten the time of detention and the time in which the detainee doesn't have the right to meet a lawyer, which is also a serious problem because the right to meet a lawyer is sometimes infringed according to the law, but yet. This is why, in each case of these cases, the Supreme Court accepts the material, asks the questions, the security people appear in front of us, and we try to ask them questions, not to interrogate, but to ask them questions and to get answers. What is the reason for keeping a detainee? Unfortunately, many of them really have enough information. But the fact that the court will look into this information in itself has a serious power. The most typical examples for our system of balancing between security needs and human rights are the cases regarding the security fence. You know that the purpose of the fence, we call it security fence, some call it the wall, is, of course, to prevent suicide bombers with cars to enter the country and to cross and enter the territory after a very, very terrible time we had of suicide bombers. For that purpose, the fence is comprised of a number of components, including a smart fence, an anti-vehicle obstacle, and an additional delaying fence. The length of the entire fence is should be approximately more than 700 kilometers. It is not yet built. I think it was stopped. In certain areas, it's about 400 kilometers where the fence has already been erected. The fence is, of course, a very, very heavy burden on the population because it is built on private farms, private land. More than 100 petitions have been filed in an attempt to attack the legality of orders issued by the IDF commander to take possession of lands for the purpose of the fence. Most of them were filed by Palestinians, but others were also filed by Jewish Israeli settlers. The most because this separates the territories from Israel. The most notable petition was the one dealing with the route of the fence. This was the first important one in Bet Zurik, very near to Jerusalem, about 40 kilometers of a fence. All of the fence cases deal with areas that are very close to our home. Just imagine how difficult the balancing process is. The petitioners pointed to the resulting harm in the form of land loss and damage, limited access to farming, and restriction on free movement. The respondents argued that the security fence was a necessity and legitimate barrier against potential terrorist attacks. Well, we decided it was necessity, security necessity. It is very harmful to the population, no doubt, even today after our interference, but this is the terrible situation that we face. The first opinion on the fence, the important opinion, was written by President Barak. The court accepted the respondents' claim that the fence was built for reasons of national security and that according to principles of international law, taking of land for that purpose of self-defense could be justified. In this regard, the court determined that the proper balance between security considerations and the rights of the local residents by applying the proportionality test. Since then, all defense cases were reviewed with the proportionality test, which is found in both in Israeli administrative law and in international humanitarian law. Within this framework, the court ruled that the IDF commander did not exercise his discretion proportionately and must reduce the infringement upon the local inhabitants' rights and interests, even if it cannot be totally avoided by alerting the path of the fence by altering it in most areas complained of the petition. The principles laid down in this case became guidelines for the route of the entire fence. What happened later is that the government itself changed in most of the areas the route of the fence, taking into consideration the guidelines written by the court. Only a short time later, the International Court of Justice, the ICJ, issued its advisory opinion regarding the legal consequences of the construction of the separation fence, as they call it, the wall. They found that this was only for political purposes and not really a security need. After the advisory opinion was given, petitioners asked us to change and review our previous decisions according to the ICJ's decision. Well, then another judgment was written, and this was a very important one, in which we referred, President Barak referred to the ICJ's opinion and found the differences between the conclusion of the International Court and our court, yet accepting the norms laid by the ICJ. We said according to the same norms. But while the ICJ based its judgment upon partial information, Israel did not defend the case in the International Court. In the Betzuri case, an extensive factual basis was laid before us. This was one difference. The second difference stems from the fact that the case before the ICJ regarded the general route of the fence, while in the Betzuri case, we dealt with one segment of the fence, 40 kilometers long, whereas in other petitions pending before us, other segments were examined. Now, no one would believe that in the Supreme Court, we do sit with aerial photographs and with maps, and we ask for an explanation from the military commander for every segment of the fence. Why is it needed? Why can't you have the route on the other side? Didn't you take into consideration town planning, which was found once that they did? And other reasons. You have to take only security measures and needs, necessity in consideration. Well, in this case, where they asked us to change according to the ICJ's decision, we accepted, as I said, the norms of the ICJ. We thought that the fence created an enclave, a closed one, that the Arab, the Palestinian residents couldn't live in, so we ordered to change the route of the fence. Yet, of course, as I said, we accepted that the fence is a military necessity. Well, I'm not an expert for that. We are not an expert. They did say that it influenced a lot, and in places where the fence was erected, they lowered the number, almost voided the entrance of suicide bombers to the country. So, as I said, we accepted the norms. We read carefully the ICJ's decision. I don't want to say if it was political or not, obviously you can imagine, but we took their norms and we tried to apply them on the situation after reviewing the facts in our cases. In our judicial review of the fence cases, we instructed the military commander to weigh two main considerations when determining the route of the fence. The first is the security military consideration, under which the military commander is permitted to weigh considerations of security of the state. And you won't believe it. They come and they claim this is a high hill, here we can defend, this is too low a value, we cannot defend, and we're listening to that. And the other was, of course, the second consideration is the rights of interest and the interests of the local Arab population, which is protected population according to the international humanitarian law that applies in the territories. The right to property and the right to human dignity of every individual must be protected by the military commander as long, of course, as there are no real threats or security needs, necessities. This consideration, security needs on the one hand and the needs of the local population on the other, often conflict with each other. This is obvious, of course. So certainly is the case regarding the construction of the fence is a very good example for that conflict. Therefore, the military commander must create a balance between the conflicting considerations. And with this, we reviewed and interfered many times. Sometimes the state representatives themselves came to an agreement or compromised and said, well, we accept. There is an alternative route, not the best one, but this could be enough for our needs. And this is how the cases ended. This happened too. Well, very unusual cases that we had in the last year were regarding to the situation in Gaza. The decision of the government to cut some of the electricity supply to the Gaza when the armed conflict started and the Hamas took over in Gaza. The new legal situation created in Gaza after the IDF withdrawal brought us into an armed conflict with the new regime of the Hamas terrorist organization that took over in Gaza. This is a very complicated, bad situation. The international laws of belligerent occupation do not apply anymore because we withdrew. And the legal norms are of an armed conflict. Thus, the court had to deal with a set of new cases regarding the humanitarian duties of the State of Israel during the armed conflict. We came to the conclusion that the duties in that situation on the state are not the same as they had when the state was keeping the territories. In a decision given a year ago, our judgment regarding the legality of the government's decision to limit the supply of fuel and electricity to Gaza. And it is strange, sometimes it looks strange, unbelievable, that people from an area of an armed conflict, through human rights organizations, come to the court, of course, of the other party to that fight, which is really a very embarrassing situation. Yet we're talking about humanitarian needs. So the petitioners were several human rights groups as well as residents of Gaza Strip. A person in charge of electricity plantation in Gaza came to the court while the hostilities took place and argued that the various limitations upon supply of fuel and electricity do not fulfill the basic humanitarian needs of the residents of the Gaza Strip. And the circumstances, as I said, were combat activities that have been taking place in this area and the continuing terrorist attacks directed against the citizens in Israel. They were intensified during the Hamas regime and worsened since they took over. Regarding the legal framework in Gaza Strip, we stated that since September 2005, Israel no longer has effective control over the events in Gaza. The military government that had applied to that area was annulled in a government decision when Israel withdrew. No Israeli soldiers could run the area and control it. We found that the state does not have a general duty to look after the welfare of the residents. Anyway, it can't effectively do it because the government is Hamas government. So they don't let it. And if you bring in fuel, they take it. So, and not always apply to the population, normally. And we cannot be responsible for the public order. Yet, in this status, we cannot enforce the regular civilian life and order. We determined that the main duties of the state relating to the residents of Gaza Strip are derived from the situation of armed conflict that exists between us and the Hamas organization, from the extent of the State of Israel control over the border crossing between it and Gaza Strip, and from the relations which have been created during the years. We do have duties, but not the same duties that they claimed for. As a result, we said part of Gaza is dependent on our electricity, so we have to supply the electricity. This is why, as I said, we did have attacks on Israeli citizens. But we found that the duty obligating Israel is derived from the basic humanitarian needs of residents, and that the state is no obligation under international humanitarian law to allow passage of an unlimited amount of electricity and fuel into the Strip, because in the circumstances of it, in fact, it was also used and can be used by the terrorist organizations for the objective of striking the civilian population of Israel. We, of course, emphasize this sad situation that civilian population find itself, unfortunately, in a territory in which combat is taking place, and they are the first and primary victims of the combat situation, even when efforts are being made to reduce the harm to them. In the territory of the State of Israel, as well in the era of terrorist attacks that have been continuing for years, the immediate and main victims of combat situation are the civilian population. However, regarding the actions carried out against Israel, that is by no means random or collateral harm, but rather frequent terrorist attacks aimed directly at the civilian population and intended to strike innocent civilians. That is the difference between the state, a democratic state fighting for its life, in the framework of the means that the law puts at its disposal, and terrorist organizations that rise up against it. In conclusion, we decided that as it is controlled by a murderous terrorist organization which acts tirelessly to strike at the State of Israel and its inhabitants, violating every possible rule of international law, which are directed indiscriminately towards civilians, men, women, and children. So, in the light of the information that we got, we decided that the state has a duty to supply, but much less. I mean, only what is really needed, fuel and electricity, and not all the needs of this area, which, as I said, also were used by the terrorist organization. So we had also cases during the war there as to medical supply, water supply for the victims there, and they claimed that they do supply it. As much as we could review it, we decided that it should be done. And we did it, as I said, in real time, because this was imminent and very, very urgent. So while acknowledging the difficulties of gaining all the relevant factual information in real time during a period of conflict, the court pressed the government to produce additional information to ensure that the proper approach to medical personnel and casualties is being used. And the government didn't deny it. They, of course, declared that they accept this notion. Well, you see, those are very unusual examples of what comes to our court in a really difficult, complex situation of war activities, of terror activities, while the need, because it happens every day, because we are there, and we have to preserve the basic human rights, possibly in a situation like that. As became clear since 9/11, the plague of terrorism is spreading and rearing its head every day in different parts of the world. Western democratic states have prepared themselves for a response to terror in the struggle against it, and have even equipped themselves with new legal tools and methods for this fight. Israel has had emergency laws since its founding. Its struggle is an old one, although it became more difficult in the last few years. The government and the Knesset, they, as elected bodies, may respond to public opinion in deciding how they will deal with terror. They are under pressure, which is understandable. However, the professionalism and the independence of the judicial system obligates us as judges to exercise objective judgments unaffected by public pressure, even though we all live in the heart of this terrifying reality. In exercising judicial review, our premise is that the law is not silent before the guns of war. Our decisions on these issues, as you can understand, do not always win public applause. Some think that the court, in exercising its judicial review, restricts the operational and deterrent capabilities of the executive branch and interventions in areas beyond the scope of the jurisdiction. Some politicians are calling to introduce legislation that will limit the court jurisdiction on security issues. But I can tell you that if in Israel the court jurisdiction will be limited on security matters and security issues, it will be limited in a very wide scope, because so many cases of this kind in our reality exist. So others think that the court's protection of human rights is insufficient, and we are criticized for that too. According to them, not enough has been done to reduce the number of human rights violations on the civilian population in the territories, a civilian population which is suffering greatly as a result of the operations adopted in the war against terror. The answer to this criticism is that the court examines the issues before it according to prescribed legal criteria. The court reviews only a minority of instances in which security concerns are balanced with human rights. Like courts in every other country, our court is not an institution that initiates judicial review. Our court considers only those matters before as they are brought before the court. Our belief is that the courts fulfill its role when it exercises judicial review in times of war as in times of peace. Sometimes, and some people think that we can avoid it. I don't believe it could be done. A democracy that ignores basic principles of human rights is liable to give terrorism the victory it seeks. Let us hope that the difficult times that we are experiencing will pass. Not that we have basis to be very optimistic, but we have to prevail. And that we will all be able to advance the values of law and justice in times of peace. Thank you.
Microphone, because we believe we still have the people in Makash 50 with us. If you could please wait for a microphone before speaking, that would be really helpful. And actually, if Elizabeth, you could send the microphone over to here.
Thank you for your Thank you for your remarks today. My question concerns something that I didn't hear you speak about, which is the issue of settlements. Now, you mentioned in your talk about how there's different levels of law applied within Israel, within the territories, Israeli law and international law, and I'm wondering, where do the settlements fall within those two categories? Often it's argued that perhaps under international law they are illegal, but under Israeli law that might be different. And if maybe you could touch on perhaps your opinion on that and where you think the settlements fall between international and Israeli law and the justifications for that. Thank you.
Well, our court never decided if, according to international law, what is the status of settlements. This is a real political issue. We have some, you see, some say this, well, I don't want to go into the arguments of both sides. This is a political issue that basically will hopefully be settled in any agreement that will be. But what you mentioned is there are illegal settlements from the Israeli law point of view, not international, because they didn't get a permit from the government, and every settlement in the territories should be a decision of the government to put them there or in another place. So those that we call illegal from the Israeli point of view, the government declared in court that they will be pulled out when the situation will be fit, and some of them are pending cases, so I can't answer more than that.
Next question.
I'd like to follow up on that question. You spoke of the applicability of the Fourth Geneva Convention to the occupied territories. That pretty clearly prohibits an occupying power from moving its population into the occupied territories and settling them there. So how do you reconcile the two things that you just said? Well,
the question is how you interpret the international norms. What we declared is the Fourth Geneva Convention, which was interpreted by the court years ago. This is a situation that exists more than 40 years. Those humanitarian parts of the Geneva Convention, humanitarian norms are applied, and this is the examples that I gave as to detentions, as to other measures taken against population. Settlements is a completely different issue, as long there was an Israeli, of course, claim when it's not private land of others, then it becomes a political question. If you don't take the land of someone else private, but it is public or it belongs to the state, then the question is what state has the right to it. It's a very complicated issue that never came that way in front of the court. But as I said, the humanitarian parts of the convention are applied.
Thank you. Can you tell us a little bit about the torture jurisprudence of your court? You spoke of administrative detentions, but in terms of the issue of the extent to which physical intimidation or physical violence can be used in the interrogation by state agents, what is the jurisprudence, and also how is torture defined? Is it defined the way the Bush administration does, that it has to be something where you'll basically kill the person, or is it more like the Obama administration, a little more lenient definition?
I don't know enough about Bush administration. I will say, but what we decided, and we decided the case in 1999. The court has a very famous judgment that declared that no special methods of interrogation, which are not allowed, affected by the law, are not to be used. All methods, even in cases of real danger, when you need urgent information. The only exception could be when there is, like in a criminal law, the claim of necessity. This couldn't be allowed in advance. This should be defended if, after the thing was done, it should be found that it was, like in every criminal case, a force because of necessity. The rule is that no torture is allowed, and this is a very broad definition of what consists of torture. Actually, the court at that time didn't even want to know what systems are. It's not like the European Court with the 5 techniques. There is a whole story. The court didn't accept any information about it because it decided that it's totally banned. There shouldn't be any torture. So this came before the court, and the decision was very, very strong. I mean, at the beginning, the state really claimed that some special methods are needed when you deal with terrorists because you need urgent information, because it's not for interrogations for criminal proceedings. Those are interrogations to save life. This is true. But as long as the law does not allow it, the court banned it. And then it's the responsibility of someone who takes those interrogative systems to excuse himself when it was done, the ticking bomb.
I have 2 questions regarding compensation. The first is about the fence. Once it has been adjudicated where the various bits and pieces of the fence are going to land, to what extent are the owners of that land fully compensated, considering that often their entire livelihood for eons to come is at stake? The second question about compensation is, in the UN compound recently, when the building that contained medicines and the other building that contained food.
I don't know yet. This is something which is interrogated, and I have no information.
For that yet, to see whether the UN will be compensated for the strategic
compensation for the fence.
Yeah.
The state is ready to compensate, but no local inhabitants are ready to take compensation. Those who are ready to it, get it. But this is, of course, also a political issue, so they won't take compensation instead of land. But this is not because of the state's position. What you mentioned, I think it is not decided yet what happened there, and I don't want to comment on it.
Thank you.
Hi. Well, thank you very much for the speech. I have a question. The selection of new justices to the Israeli Supreme Court is very different than American system. And from my personal observation, I feel like the Israeli system is not that democratic because no public officials really play a major role in the selection process.
I can't hear you well at the end. What did you say? It's not democratic because?
No elected officials take a major role in the selection process.
The selection process? So first of all, elected officials take part in electing judges, selecting the judges. I'll just answer briefly because I already answered the question of how we select judges. It's a special committee that consists of 9 members. 4 of them represent government and Knesset and the parliament. 2 ministers, 2 members, coalition and opposition. 3 are Supreme Court justices, and 2 are members of the bar elected by the bar members. So politicians are involved in the selecting process. The question is how many. It's of course very different from the American system. I believe it's more democratic because this guarantees an apolitical court, which is so important for the objectivity of a court. 2 institutions are elected and represent the people, which is very important, of course. It's the legislative body and the executive body. They should be elected. This is democracy. And they have been chosen by majority. But I'm not sure that democracy is only the rule of majority. It's first of all the rule of majority, but it's also the rule of democratic values. And this is what the court presents. This is the difference between a court and the elected bodies. This is according to our judicial philosophy. Of course, politicians think differently and they want to be more influential in the process of selecting judges.
Just a question, I guess, about politicians and judges. So politicians have the right to change the basic laws, and yet it seems that they very seldom do this. Do you think of what the reactions of politicians will be, how they're going to rewrite their laws when you make their decisions, and how do you ensure that they do follow your human rights decisions and don't overturn them?
Well, if I understood your question, we of course do not follow how the enforcement or implementation of our decision is. But the party that wins the case, usually, if it is not enforced, they come again to the court. And we do have such cases, of course. Now the legislature is able to change the law. This is true. After our decision. This is part of the democratic power that was mentioned before. I mean, the majority could not accept the rule, not on constitutional matters. If it's unconstitutional, it's not constitutional, and that's it. No. But yet, they can change a law. And this is the tension between the legislature and the court. I think it's natural everywhere, according to the background and the political situation. We do not follow how our decisions are implemented. But mostly, if we are talking about open doors of the court, NGOs and civil rights groups that are bringing the cases to the court, they usually follow, and if it's not done, they come again to the court. We had such cases.
This is a follow-up. I'd like to know what is the composition of the Supreme Court justices appointed for life? Does the majority rule apply? And the next question I have is about the death penalty in Israel. Was there anybody sentenced to death after Eichmann?
Well, the first question, what was it? Majority. I'm not sure.
Was about the composition.
The composition of the court. I'm not sure that I understood the question because, as I said, there is a committee that selects the judges.
No. I wanted to know how many.
And you mentioned for
there
life,
are.
not for life, not for life, up to the age of 70. And sometimes, believe me, it's not so long. And so it's up to the age of 70, and then we retire by law. The composition is, you see, most of the judges came from the judiciary. They were brought from the lower court to the higher court. Now, I'm not sure that it's most of it used to be like that. Now we have 2 lawyers that come from the private field, appointed directly to the Supreme Court. We have a former Attorney General, a former state attorney, that's me. And this is how normally the court is composed from those different backgrounds. And it's not a bad composition.
How many justices are there?
We have 14, normally we are 14 justices. For more than a year, we are only 12 justices, which is a very difficult thing with the burden of cases we do have, with a lot of cases we do have. And this is how we have to measure until new appointments will be made. It's not easy because you need a majority, and to the Supreme Court, we are now, according to a new law, need a majority of 7 out of 9. So we have to come to the agreement with the politicians in the committee to bring a majority of 7 out of 9. The candidates' names are published. Everyone can oppose it to the committee, not public debate or not public procedure like the Senate, but we have, if someone is opposed, we have it brought to the committee. And normally we discuss and we come to an agreement. Now we'll have to come, as I said, to a majority of 7 out of 9 to select 3 justices. We have more than a year. We have 2 vacancies and maybe 3. So this is... Now, death penalties. After Eichmann, no one was executed. No?
Yes. Thank you for the first answer. Now, I ask if there is a death penalty in Israel. I know it's done only against crimes against...
So I said, it's Nazi criminals can be, of course, tried to a death penalty. This could be, but it never happened. I mean, there was the Manu case, but the Supreme Court acquitted him. So we didn't have any other case of execution.
Yeah, thank you. The final question which I have...
Thank you very much. At dinner, you mentioned that at some point the court had... Sorry, at dinner you mentioned that at some point at dinner you mentioned that...
This was a secret at dinner,
it was a
so
secret
they don't
question. That the court had interviewed a German jurist, and you had asked him, how do you enforce your decisions? And it occurs to me to ask you the same question because, at least in this talk, one thing that struck me as quite interesting was the only, I won't say mechanism of enforcement, but at least practice of pushback on the part of the court against the executive branch. You mentioned a couple of times a kind of resistance that they might, or a reticence that they might have as a result of certain impositions, such as further fact-finding that you might impose on them. But that seems a pretty slender thread as far as enforcement or holding as a way for the court to hold its ground against executive power.
I couldn't hear you very clear, but if the question is how do we enforce and if there is an enforcement, first of all, there is a very good tradition of enforcement. Usually there is respect for the court and a court's decision. Sometimes it takes more time than we believe, but they are implemented. This is the normal situation. Cases where we decide, I think, there were some cases the government was really very unsatisfied from them. When we decided the government has to give more shelters to children and to finance building schools with, to defend them from the missiles. So the government said the court will decide about our budget. Why do they force us to put shelters there? But still they build them. Not in the same time that we expected them. It was a bit difficult to implement, but they do. Many other decisions, most of them we know. Because you see, we're a small country. You know if it's enforced or not. And if someone fights for a principle, not with the court, the people know. We don't know. We really don't follow. I didn't mean that we, the justices, are following if they are doing it or not. We are not, of course. But the people who initiated the case, they will come again. And they do come again if it's not, because this is why they initiated the case. We don't feel now a terrible problem of not enforcing, not implementing our decisions. Sometimes when there were a few cases in which we ordered the Knesset to legislate, and the legislation process was more complicated. So they asked to postpone the date of the legislation, to give us more time to this happened. Or they had a special law in a very controversial issue for a few years to postpone the legislation. But they cannot just ignore our decisions. This is normally not done. So I hope it will not happen.
Because we started very late, I know there are still questions. I think there will always be questions. I think what the President of the Supreme Court of Israel knows is that there's a never-ending supply of legal questions that come before the court and that come before her. But I'd like you all to join me in thanking her.
Thank you so much.